Therefore, you should remember that whatever the lawyers say, however they say it, is simply argument that is being submitted for your consideration. Second, remember that the lawyers themselves are not witnesses in this case. So if a lawyer asserts as fact something that is not based on the evidence, you must disregard it. Remember, nothing the lawyers say at any time is evidence, so nothing the lawyers say during summations is evidence. You have heard the evidence and must decide this case on the evidence as you find it and the law as I explained. Third, during the summations, one lawyer's recollection of the evidence may, in good faith, differ from the recollection of the other lawyer or from your own recollection. And the lawyers will undoubtedly differ with each other on the conclusions to be drawn from the evidence. It is your own recollection, understanding, and evaluation of the evidence, however, that controls, regardless of what the lawyers have said or will in a moment say about the evidence. You and you alone are the judges of the facts in this case. If during your deliberations you need to have your recollection of the testimony refreshed, you may have all or any portion of the testimony read back to you. And fourth, remember that under our law, I am responsible for explaining the law, not the lawyers. If you think there is any difference between what the lawyers may have said and what I say the law is, your sworn duty as jurors is to follow my instructions on the law as you promised me you would. And fifth, if during the summations I sustain an objection to a comment of a lawyer, that comment will be stricken from the record and you must disregard it as if it were never said. If I overrule an objection, the comment will stand. Whether I sustain or overrule an objection or on my own indicate that a comment must be disregarded, my ruling indicates only that the comment does or does not violate one of the rules of law set down for lawyers to follow during a summation. It is not an attempt to indicate that I have an opinion on what is said, or of the facts of the case, or of whether the defendant is guilty or not guilty. Remember, under our law, you alone judge what facts, if any, are proven, and whether the defendant is guilty or not guilty. Not I, and not the lawyers. We will now turn to the summations. The court will recognize Mr. Eisman for the defense. Thank you, Your Honor.
Good morning, everyone. I want to thank you for your attention and service. You've been very attentive and patient as we've brought the evidence before you during this serious trial. And I'm going to ask you to indulge me as I review the facts and the evidence as applied to the law in this particular case. And I'm going to ask you to continue to indulge me as I talk for a decent amount of time this morning to review the facts and the evidence, because this is the last opportunity that I get to speak on behalf of Mr. Fisher. After I am done and I sit down, you don't get to hear from me again. And no one else can make any other argument, point anything else out on Mr. Fisher's behalf. Mr. Fitzpatrick will then speak, and then you, the judge, will instruct him on the law, and then you will enter into your deliberations and take as much time as you need to arrive at your final conclusion in this case. And so I'm going to begin today and this morning where I started this trial, where every trial in a courtroom like this begins, which is with the facts, the evidence, and the law. Not emotion, not sympathy, not rhetoric, not loud shouting, not emotion, the facts, the evidence, and the law. So this morning I'm going to go through the facts and the evidence that has been presented to you during this trial and explain how I believe it applies to the law and why the only verdict at the end of the day is that Michael Fisher is not guilty of the only charge against him. It's manslaughter in the second degree. Now, at the beginning of this trial, I asked you to pay attention to three very important things. First was the importance of hindsight bias. Second was the importance of context. And the third was the importance of the burden of proof. The burden of proof is the government's, and it is the way that you apply the laws instructed by Judge Bauer to you and to the facts and evidence that are provided in this case. And I want to go over what I expect the court is going to instruct you on the law, because that is how you begin to apply what we have learned during this trial to the allegation. Michael Fisher is charged in one count, manslaughter in the second degree. Manslaughter in the second degree, we'll learn, has two elements. The government has a responsibility and an obligation under the law to prove manslaughter in the second degree by establishing that Michael Fisher recklessly caused the death of Robert Brooks, as alleged in the indictment. The indictment, as was presented to you during the opening statement, is not evidence. It is the allegation. It puts us on notice of what we're defending against. It tells you what you are to determine. It's not evidence. You're going to be instructed on what recklessness is and what causation is. These are lengthy descriptions because they contain many different parts. I'm going to go through those different parts with you. As Judge Bauer just said, there's any disagreement between what I say, you go with what Judge Bauer says. Okay? The first thing that the government has to prove beyond a reasonable doubt to establish manslaughter in the second degree is the element of recklessness, so that Mr. Fisher acted recklessly. You're going to find that recklessness has several different parts. The first one is that the government has to establish beyond a reasonable doubt that the defendant engaged in conduct. Which creates or contributes to a substantial and unjustifiable risk that another person's death will occur. So engaged in conduct, that's where we're going to start the analysis. You will be instructed that conduct can include an omission of a legal duty, and that is the prosecution of the government's theory. Mr. Fisher had a legal duty to intervene or to provide medical care, and then he failed to do so. That is their theory of conduct in this case as it applies to the recklessness element. The court is going to instruct you on that legal duty. So just to establish the conduct portion of recklessness, you're not going to have to go through the entire legal duty to intervene analysis, which we spent a fair amount of time with Assistant Commissioner the Assistant Commissioner from DOCS, Marcello, reviewing when he testified. The court, I expect, is going to instruct you that corrections officers, when they are on duty, have a legal duty to intervene in circumstances, and he's going to describe these circumstances for you. That they have a legal duty to intervene when they observe another staff member using force that the observing corrections officer reasonably believes to be clearly beyond what is objectively reasonable under their circumstances. There's more to it, but I'm going to pause there. So it is from the observing officer's perspective, in this case Mr. Fisher's perspective, and then it has to be clearly beyond that which is objectively reasonable under the circumstances as they are appearing to that observing officer. In such circumstances, the correction officer has a duty to intervene to prevent the further use of unreasonable force when the staff member has a realistic opportunity to prevent harm. So it's not just that there is a duty to intervene to stop what is clearly and objectively unreasonable force. That duty only applies to intervening to stop the further use of excessive force that the staff member has a realistic opportunity to prevent. Now, it's what is objectively reasonable, clearly beyond that, what is objectively reasonable. How are you supposed to determine this from the observing officer's shoes? You're going to be instructed that within this context, when determining whether force is objectively reasonable, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene. rather than with the 20/20 vision of hindsight. Can't use additional information. It's from that observing officer's perspective without the benefit of hindsight. The calculus of reasonableness must embody allowance for the fact that officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. So you have to give this reasonable officer, when you're assessing whether it is clearly beyond that which is objectively reasonable, you have to give this reasonable officer an allowance without the benefit of hindsight, and allowance also for the fact that these are evolving situations, that judgment calls are made about how much force is necessary in those situations. You have to give that allowance to that reasonable officer when you're doing this assessment. The reasonableness inquiry for determining whether force is excessive force is an objective one. The question is whether the officer's actions are, quote, objectively reasonable in light of the facts and circumstances confronting them without regard to their underlying intent or motivation. Again, a reminder from the perspective of the observing officer or the reasonable officer in that observing officer's shoes without the benefit of hindsight. That is the totality of the duty to intervene. That is one part of conduct. Conduct is one part of recklessness. Recklessness is one part of manslaughter. The government has a burden to prove beyond a reasonable doubt each of those rungs on that ladder to each of you beyond a reasonable doubt to establish conduct. If you have any doubt about any of that, it's an acquittal, not guilty. In a few moments, we're going to be going over why there are several very strong and very clear reasons why they do not meet that burden. The government also has an additional theory of a duty to intervene. It's a duty to provide medical care. And a failure, they're accusing Mr. Fisher of not intervening and providing medical care as he was obligated to do, and he'll be instructed. The corrections officer on duty and serving as a corrections officer under the law has a legal duty to seek medical assistance from qualified medical personnel, such as a physician, emergency medical technician, physician's assistant, or nurse, for incarcerated individuals who complain of pain or demonstrate medical distress following a use of force incident when it is reasonably safe to do so. When it is reasonably safe to do so. That is the alternative theory of the failure to intervene. Medical care was not provided. That, again, is one part of conduct, which is one part of recklessness, which is one part of manslaughter. Additionally, the second element of, or the second part of recklessness is that this conduct, again, we're at the very first part, the first part of recklessness, that this conduct has to create or contribute to a substantial and unjustifiable risk that another person's death will occur. This has to do with recklessness. Okay, we're still on recklessness, and this is just about what Mr. Fisher's conduct has to do, what the government has to prove beyond a reasonable doubt his conduct did, that it created and contributed to a substantial and unjustifiable risk. That's to prove that beyond a reasonable doubt. The next element of recklessness is that when he is aware of and consciously disregards that risk, the government has to prove that Mr. Fisher knew of and consciously disregarded the substantial risk of death to Mr. Brooks. Beyond reasonable doubt, they have to prove that. And they also have to prove that when that risk is of such a nature and degree that disregard of it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Those are the totality totality of the instructions that I expect you're going to receive regarding recklessness. You should pay attention to the various different parts of recklessness. There's a lot there. There's a lot of different assessments that need to be made. And if there's a doubt as to any wrong on that ladder, regarding the definition of conduct, clearly beyond the objective, what is objectively reasonable, any of those elements, it's a not guilty verdict immediately. But it's not just that. The government now has to prove causation. That this conduct caused the death of Robert Brooks. Causation, its own particular legal instructions and meaning that are going to apply here. You're going to be instructed that a person causes the death of another when that person's conduct is a sufficiently direct cause of the death of another. And that a person's conduct is a sufficiently direct cause of death when, one, the conduct is an actual contributory cause of the death, and two, the death was a reasonably foreseeable result of that conduct. So it has to be an actual contributory cause, number one, and two, it has to be reasonably foreseeable. What is an actual contributory cause? You will be instructed that a person's conduct is an actual contributory cause of death of another when that conduct forged a link. Pay attention to these words. Forged a link in the chain of causes which actually brought about the death. Forged a link in the chain of causes which actually brought about the death. It goes on to say, you'll be instructed that in that conduct set in motion or continued in motion the events that were ultimately resulted in the death. So you have forged a link, and then the conduct has to set in motion or continue in motion the events that resulted in the death. More importantly, you're going to be instructed that an obscure or merely probable connection between the conduct and the death is not sufficient. It can't be guesswork, it can't be speculation, it can't be a maybe. It's to forge that link. Additionally, you'll be instructed on what reasonably foreseeable means. When is death a reasonably foreseeable result of the conduct? Is when death is a reasonably foreseeable result of a person's conduct when the death should have been foreseen as being reasonably related to the actor's conduct. That brings us back to that very first element, conduct. The duty to intervene under those two circumstances. It has to be reasonably foreseeable based upon the theory of conduct. It is not required that the death was the inevitable result or even the most likely result, but it nonetheless has to be related back and reasonably foreseen to that conduct. So that, you're going to get more instructions from that. But that is the heart of the various decisions that you are going to have to make. So that is why I began this case by saying that you need to be mindful of hindsight bias. You need to be mindful of context, and that these things are important, as well as the burden of proof. And they are important because you are going to be evaluating the people's allegations against Mr. Fisher based upon looking at what he knew at the time and nothing more. What is it that the government proved that he knew at the time he was observing the things that he saw and what he experienced? What was available to him? What did he know? Without the benefit of hindsight. And hindsight bias is important because you cannot allow the additional information that you've necessarily had to learn during this trial improperly influence your assessment of his conduct at the time. And that's why I brought up context at the start of this trial. Context is so critically important because you need to understand it from Mr. Fisher's perspective. You need to understand globally what was happening to put everything into its right position, and then understand it from Mr. Fisher's perspective. What did he know?
So I'm going to suggest this, that the best evidence of making this assessment is the body-worn camera footage of Michael Fisher. And then you review the body-worn camera footage of Michael Fisher. And we're going to do this in a moment. In that, as you are reviewing it, you recall the evidence that we learned, Michael Fisher learned and was exposed to during the trial. Nothing more. Because that's the standard. From his perspective, or a reasonable officer in his shoes. Now, something can be said about, well, body-worn camera footage, it's pointing this way, but maybe they're looking this way. So maybe they didn't see it. Sergeant Trombley made a big deal about that. This footage is showing things, and he's claiming not to have a recollection of it. The cameras are here, but eyesight is up here. So maybe there's a different view that was possible at the time. Maybe there was additional information that could have been obtained. But what is the evidence here in this courtroom, and what is the best evidence in this courtroom about what Michael Fisher knew at the time? That's his body-worn camera footage. That is the best perspective that you all have of what he experienced and knew. If you are to do an assessment of what he observed and how he was supposed to decide things, and what a reasonable officer in his shoes would have done under those circumstances, as applied, as Judge Bauer is going to instruct him on the law. And I hope you watch this body-worn camera footage 10 times, 15 times, 50 times. Because each time you do, you'll have doubt. Because you have to watch it again. Real life does not have a rewind button. Real life does not have a pause button. Real life does not have the ability to have a split screen where you're seeing other people's perspectives. Real life does not have the ability to pause and say, oh, I wonder what's going on there. Let me see that again. I'm going to back it up. If you're watching this body-worn camera footage and you're asking to rewind, that means you have a reasonable doubt under the law, as it's going to be instructed to you. Because Michael Fisher did not have a rewind button. He did not have the ability to enhance. He did not have the ability to pause. He did not have the ability to get a different perspective of what was happening in the room. Every single time you pause to get a closer look, that's a reasonable doubt. Every time you rewind to get a different perspective, that is a reasonable doubt. Every single time someone asks to see it again, there's a reasonable doubt, because you can't use hindsight, and he didn't get to look at it again. So look at it as many times as you need to, and every time you do, it's a reasonable doubt. So what we're going to do now is I'm going to play to you Michael Fisher's body-worn camera footage. And I'm going to go through the evidence from Michael Fisher's perspective about what he learned and was exposed to that night. And you can make your decision, and you can deliberate all you want based upon that, and see as many times as you like, as many other perspectives as you like. You want to project this? Okay. All right, so this is Michael Fisher's body-worn camera footage. You can see in the upper right-hand corner, it's 9:17. A couple seconds after. At night. We learned that he was a corrections officer on duty at Marcy Correctional Facility, which is a New York State prison, where he guards incarcerated individuals. Michael Fisher doesn't know anything else about what's happening at Marcy concerning Robert Brooks at this time, so no other evidence of that. make you sit here and watch the ceiling for several minutes. You can watch this if you'd like all the way through. I'm going to fast forward just a little bit. Keep in mind the clock. We're at 21 hours, 18 minutes, 40 seconds. I'm going to jump ahead. We're at 21 hours, 19 minutes, and 40 some odd seconds. We're going to watch this for the next 30 seconds or so. We have some movement at 21:10. Mr. Fisher is responding to the call for response. You can see that he's moving rapidly. It is an emergency situation. He is rapidly moving to the call, and he stops. Sergeant Trombley has just called off the call for response. The emergency is therefore over. What you're going to see is Mr. Fisher now walking to the infirmary. We've learned that after a use of force or a call for response, the policy and procedure is that the incarcerated individual is always brought to the infirmary. Sergeant Trombley testified that this break room where Mr. Fisher was is about 0.2 of a mile from the infirmary. I'm not going to make you watch the entirety of this walk in the dark. You can watch it if you'd like. There's been obviously no evidence that any additional information about the circumstances of this response call beyond it being called off, or what he was exposed to, or what was happening to this incarcerated individual, who's still unknown to Mr. Fisher at this time, has been communicated to Mr. Fisher. Jump ahead, you can see he's approaching the infirmary. We are now at 21 hours, 24 minutes, and 59 seconds. He's entering the infirmary. You can see there's been no evidence of additional information being presented to him at this time. He's about to enter into the emergency room, where we see this wall of corrections officers clearly engaged with an incarcerated individual. We see Sergeant Mashaw on the right, Sergeant Trombley on the left, Officer Farina with his hand hurting, as we learned that he was just bitten by an incarcerated individual. Sergeant Trombley looking right at him. Sergeant Mashaw in control of the room with Sergeant Trombley. Farina re-engaging, and then struggling with his legs, and Officer Farina yelling out for leg irons. Sergeant Trombley ordering Gallagher out to go get the leg irons. And there goes Officer Gallagher to go get the leg irons. Officer Walrath has jumped in to help get control of the incarcerated individual's legs. Sergeant Trombley just orders Kiefer out. He's in control of that room. Orders Kessler out. They were involved. It's the matter. That's the policy. Fresh hands, fresh people that aren't involved. Walrath had just asked Sergeant Mashaw to step aside so that he could use force. Sergeant Mashaw steps aside and is observing the entire thing. Gallagher returns with the leg irons, places them on the incarcerated individual, consistent with Sergeant Trombley's orders. Morath and Kessler are smiling after this. You see Mr. Brooks sitting up. Officer Trombley at this time asks him, "Are you done? Are you going to comply?" Because his assessment at the time was that Mr. Brooks had been non-compliant. Not that he'd been violent, they'd been non-compliant. Sergeant Trombley, who was mere feet away in the room the entire time, testified, and he's the prosecution's witness in the cooperation agreement with the prosecution, that at that time he did not order medical personnel in because he did not believe that there was an imminent need for medical intervention at the time based upon the information that he had in the room. Sergeant Trombley is ordering him into the corner so that he can be stripped, so that a medical evaluation can take place and medical treatment can follow. That's what Sergeant Trombley testified to. Sergeant Trombley also testified that Sergeant Mashaw was in charge of that room. There he is, never leaves. Sergeant Mashaw smiling in the vicinity of Michael Fisher after being in charge of that room. At this point in time, remember the testimony of Sergeant Trombley. He's ordered into the corner so that he can be stripped, so that the medical evaluation process can begin. Trombley's just come back into the room, talking to Sergeant Mashaw. Look at his demeanor. Look at Sergeant Trombley's demeanor there. There is a concern on his face. You see the nurse, Kyle Dashnaw, waiting to go in. Sergeant Trombley then testified that he ordered that they place Mr. Brooks back on the gurney because it was evident that he could not stand on his own. This is clear right there. on Sergeant Trombley's order, the nurses are going to be allowed in. 21 hours, 31 minutes, and about 50 seconds. The nurses begin to enter to do their thing. We begin the medical assessment. Nurse Kyle Dashnaw then testifies that based upon his initial medical evaluation, Mr. Brooks' vital signs were stable. He was unconscious but stable, and that no immediate medical intervention was required. That changed. That changed because his vital signs changed, and they responded, provided the BPM, breath mask. They provided Narcan because he was unconscious and there was a policy for it. And when his heart rate changed, they applied the AED and started emergency response care. To Kyle Dashnaw, the trained nurse, medical provider, he could not tell. As Dr. Markolova testified to this, she has done over 500 autopsies. And on an external examination, she could not even tell that Mr. Brooks' hyoid bone had been fractured, and the amount of damage that had been done to his neck. The other damage internally to his body where he was bleeding. None of that was visible or known to them on an external examination. It only became evident to Dr. Markolova after an internal examination. As you're reviewing this footage, I'm going to ask you to ask yourselves these questions. Where is the evidence that Mr. Fisher's conduct created or contributed to a substantial and unjustifiable risk of death? How did what he failed to do create anything? How did what he is alleged to have failed to do contribute to anything? Where is the evidence that he was aware of and consciously disregarded that Mr. Brooks faces substantial and unjustifiable risk of death? Sergeant Trombley talked to the man after he had been beaten several times, had a direct face-to-face with him, and did not order medical care because he didn't appreciate how badly he was hurt. But he had ordered medical care to begin and eventually begin that process. He talked to him. Asked him, "What have you done? Are you going to comply?" No evidence that Mr. Fisher ever had that opportunity to speak with Mr. Brooks or to evaluate him. We never saw him leaning over Mr. Brooks like any of the other officers that we saw in the body-worn camera footage. And more importantly, Mr. Fisher obviously never saw the devastating injuries that had been inflicted on Mr. Brooks prior to his arrival. He didn't know that Officer Walrath, all 6 foot, 200+ pounds of Officer Walrath, smashed Mr. Brooks into a wall and put him into some kind of chokehold or headlock and cranked up on his neck in the arsenal. Remember where you got that information from. The defense got that information. We told you about it. We provided you with that additional context because it was important for you to understand the potential sources of what could have caused or contributed to Mr. Brooks' death. We subpoenaed their cooperating witness to testify in their case and to tell you about that chokehold. We have no burden of proof. It's their burden. We want to provide you the necessary context and information for you to make a fully informed decision and not hide any information from you about what could have caused or contributed to Mr. Brooks's death. Ask yourselves, where is the evidence that the force she observed was clearly beyond that which is objectively reasonable without the benefit of 20/20 hindsight, and allowing for the fact that these decisions about the amount of force to be used are made in uncertain and evolving environments? Where is the evidence that medical care was not provided once it was deemed safe to do so? Sergeant Trombley is in control of that room. He is ordering people around, and Mr. Fisher is just a corrections officer. That room is in control. The officers who were involved in the use of force are ordered out by Sergeant Trombley. Sergeant Trombley engages with the incarcerated individual. He orders Officer Gallagher to go get leg irons. The leg irons are applied to the struggling incarcerated individual, consistent with Sergeant Trombley's order. Sergeant Trombley then asks him, "Are you done? Are you going to comply?" Because it was understood in that room that he was not complying. Again, he wasn't violently attacking anybody. But what's Mr. Fisher supposed to know in that circumstance when his supervisor is saying such things? And leg irons are being applied. And one of his colleagues, a highly trained member with 20 years of experience, and a member of the CIU team, Officer Farina, his hand is bitten by the incarcerated individual, and that's the first thing that Officer Fisher sees when he walks in the door. All of that says that this incarcerated individual is not being compliant. I have a colleague who's been bitten. They're struggling to get control of his legs. The supervisor on scene has ordered one of my colleagues out to go and get leg irons. The leg irons are then applied, and then my supervisor asks the incarcerated individual, "Are you done? And are you going to comply?" There is no other inference that the evidence that's been adduced at this trial can demonstrate beyond the fact that Officer Fisher had no reason to believe that anything inappropriate had been happening to Mr. Brooks. He didn't have the information that was necessary, without the benefit of hindsight, without the rewind button, or without the additional information that was not available to him at the time. Where is the evidence that Mr. Fisher's conduct forged a link in the chain of causes which actually brought about Mr. Brooks' death? Where is it? How is his conduct? Think about that language, a forged link in a chain. How is his alleged inaction, his failure to do either this medical care or get medical care or to intervene in some way, how is that forging a link in any of these causes that actually caused or contributed to the cause of death? Ask yourselves that. Where is that evidence of that forged link? There isn't any. Where is the evidence that Mr. Brooks' death was reasonably foreseeable to Mr. Fisher from not intervening? Remember, it has to be reasonably foreseeable from his conduct. The alleged conduct is a failure to intervene. How is it reasonably foreseeable to him, with the information that he has at the time, in the moment, that Mr. Brooks is going to die? Where is the evidence? He's charged also as an accessory. Where is the evidence that he solicited, aided, importuned, and importuned is a fancy word for asking a lot. Where is the evidence that he solicited, aided, importuned, requested, or supported anyone who had caused Mr. Brooks' death? Where's that? How did he do anything to intentionally aid or support any of these other officers? Where is the evidence of that under an accessory theory? I've been extremely patient and diligent. The stakes cannot be higher for Mr. Fisher. I thank you for indulging me and listening to me during this case, and especially this morning. Keep these questions in mind. Review the evidence as much as you like. You can do as I suggested or not, it's entirely up to you. It's your deliberative process, however you think best to approach arriving at this important decision. I think once you hear the instructions from Judge Bauer, you'll know that if you have to rewind, if you have to pause, if you have to zoom in, get a different perspective, ask to see it again, it's not guilty. If you can't clearly, immediately answer the questions that I just posed to you after reviewing that video one time, it's not guilty. And if you can't answer any of those questions, even after a deliberative process, it's obviously not guilty. You all are the decision makers. They're the accusers. You are the decision makers. Your decisions are made on facts and evidence, not rhetoric, not volume, not fancy words. Facts and evidence. I'm not going to get to speak to you again. So Mr. Fitzpatrick in a few moments is going to get up and speak. Maybe you'll hear comments and arguments that are based on decency, humanity, and morality, about the things that people should be doing in certain circumstances. That's fine. Those are called rhetorical devices that skilled advocates like Mr. Fitzpatrick will use. They ain't evidence. Back to the facts and evidence. Apply to the law as instructed by Judge Bauer. And the unavoidable conclusion will be that Michael Fisher is not guilty. Thank you.
Thank you, Mr. Mr. Fitzpatrick.
Thank you, Your Honor. Thank you, folks, for your attention. I join with Mr. Eisman's assessment that you have been very attentive during this trial. And let me clear up one thing right away, that I don't want to be too harsh in criticizing my opponent's argument, but the fact that as jurors, if you decide to scrutinize evidence 2, 3, 4, 10 times, means that you're being a diligent juror. It doesn't mean that there's a reasonable doubt in this case. Never seen a case in prosecuting homicides for 40 years where a jury was told that if you look carefully at the evidence, that manifestly you must return a verdict of not guilty. Throughout my life in picking juries, I think I have a bias towards picking juries that are pro-law enforcement. I hope every one of you is pro-law enforcement, because what happened on December the 9th, 2024, by this defendant and others had nothing to do with law enforcement. It is amazing to me that anybody can look at those tapes and not see it for what it is. A gut-wrenching, disgusting, overwhelmingly improper, illegal, criminal snuffing out of a human being. Mr. Trombley, Mr. Kessler, both of them testified. This is what we do. We lie. We cover it up. Well, guess what? In this courtroom, in Utica, New York, today, it stops. bias. Seriously? Hindsight? Many of you saw the tape before coming into court today. Some of you even expressed your opinions when we spoke with Judge Bauer up here at the bench. Some of you said you were disgusted by it, horrified by it. What does that have to do with hindsight, bias? Nothing. It has to do with reality. Are we supposed to look at those tapes of that man being beaten like an animal? I'd say beaten like an animal, but I've never seen an animal beaten like that. Are we supposed to look at those tapes and say, wow, never saw that coming? I thought Howard Brooks walked down the hallway and testify here, and this was nothing more than an assault case. Apparently, I thought on voir dire we were talking about immoral actions by Mr. Fisher. Apparently now, they're not immoral, they're not illegal, they're great. We're gonna use these films, folks, at the next Academy for Corrections Officers. That's a great idea, isn't it? We'll teach these cons. We'll teach them a lesson. Damn it, when I tell you to get out of the van, you better get out of the van. When I tell you to put your hands in your pockets, you better put your hands in your pockets. If not, look what can happen to you. Mr. Eisman talked about the tenseness and the uncertainty of the job, as if this 148-pound, unarmed, shackled human being somehow posed a threat to these individuals. Context. We all love that word, don't we? Context. You've got to put everything in context. You know, honey, you're putting on a little weight, but don't take it out of context. It's got to be in context. Think about context for a second. What would we be talking about today if there were no tapes? If we did the Trombley and Kester way, who would it be? Robert Brooks would file some civil lawsuit. Nobody would know his name. He'd be lost to the dustbins of history. He'd work his way through the court of claims, maybe get a settlement 10 years from now. But no one would know what had happened. That's the context of this case. Mr. Eisman asked, as he should have, some very legitimate questions. How can I prove this case? How did I prove this case? Well, let me tell you in the next 20 minutes exactly how we proved this case. We start here. A guy whose entire life has been disrupted, everything he owns in a sack, told to get on a bus, and he gets 9:07. And 10 minutes later, he's hogtied, being dragged into an infirmary. Mr. Eisman asked several times, what was Mr. Fisher supposed to have done? You know what stopped the beating here? Two syllables. Enough. Someone said, enough, and it stopped. This is normal. See how normal everybody looks? You see anybody distressed other than Mr. Brooks? nurses come. They want to take a look at this guy. They have enough sense to realize something's wrong with the guy. They're told to stay out. Rena, Medal of Honor winner for Department of Corrections because he bravely reacted to getting his finger bit
Objection,
by jamming the guy's testicles.
Objection. There's no evidence of Medal of Honor being bestowed on me.
All right. The objection's overruled. Do remember, ladies and gentlemen, what you're hearing now is arguments submitted for your consideration.
See anybody looking around, running around, saying, you know, let's get the nurses in here. Let's see what's wrong with this guy. Let's just pretend that we're still human beings. So even though the call went out, and even though the call was rescinded, Fisher keeps coming. I can catch up the movie later. I'm going to go and see what's going on. I'm going to go to the ER. At 21:25, he's entered the building. He has absolutely no reason to be there. Fisher is down the hall now, just walking in. Should any wonder that he may have bit his finger? At 21:25:20, Michael Fisher walks in and sees what you're about to see. Mashaw, another worthless individual in this entire scenario. He's yucking it up with Fisher. Gee, I can't see anything wrong with Mr. Brooks, can you? He's just sitting there, you know, he's not compliant. Imagine the nerve of the guy objecting to a rag being shoved down his throat. His testicles being rearranged while Fisher stands there and doesn't do a damn thing. Exactly how much medical training do you have to know that this guy is in serious distress? Are you kidding me? Oh, well, he didn't see the internal injuries. What do you think is happening to this man? If someone listened to the summation of the defense and never had these tapes, you'd think that Robert Brooks was kicking like some football player or field goal kicker. His legs are barely moving. Look at the agony on Farina's face. Can you imagine how horrible it must feel for him? There's another officer over there looking at this and laughing. comply now, Mr. Brooks? Now that you're dying? Any sentient human being that could look at this and not realize what's happening. I wish we could hear this as well. I can't emphasize enough how important it is for you to realize that Mr. Fisher not only saw this, but he heard this. Good Lord. Fisher still standing 12 feet away, watching the whole thing. Again, the emphasis on routine, on normalcy. Nobody panicking, nobody rushing, nobody picking up a phone. At exactly 21:30:47, Mr. Fisher, after watching all this, then begins to engage with the two nurses who are standing right beside him. Watch Mr. Dashnaw's face. Love to know what it was that was said that Mr. Dashnaw thought was funny, made him laugh. Gee, I can't imagine anyone thinking something might be wrong with Mr. Brooks. After all, the injuries were internal. And finally, at 21:31:59, these two nurses are finally allowed in. And do absolutely nothing but stand around and look. according to the defense, what you've just seen, there's absolutely nothing wrong with Mr. Fisher's conduct. Nothing. Will I be able to prove him guilty of manslaughter in the second degree? But on or about December the 9th, Michael Fisher, Miss County, personally, or by acting in concert with another, caused the death of Robert Brooks, and that the defendant did so recklessly. Reckless conduct, ladies and gentlemen. You all swore to me that you would not allow personal opinions, outside influences to affect you. You swore to me that you would listen to the law from Judge Bauer. You can cause the death of a person by an omission. And frankly, there's no better example of causing someone's death by omission than what you've just seen. Did Michael Fisher recklessly cause the death of Robert Brooks? Of course he did. Not by himself. He had plenty of other helpers. Worry about them later. Be glad to tell you what happened to them. This case is about this defendant. This day. He caused it by doing absolutely nothing. And don't forget how Mr. Brooks died. It wasn't by one blow, it wasn't by one choke, it wasn't by one kick to the testicles, it was by a constellation of those. Each blow, as Fisher stood there and watched, each blow administered to that helpless man, taking the strain on his heart to such a degree that his heart stopped. And if you want to accept the testimony that you heard a few moments ago, that when this nurse walked in there and found everything fine, good luck. And Dr. Merkulova, if they had stopped, if somebody had intervened, Robert Brooks would be alive today. I picked you because you have common sense, not because you don't have common sense. I picked you because you have compassion and empathy and decency, and that you will listen and watch this evidence. And you will see exactly what Mr. Fisher is looking at there, that any human being can see. That they were beating this man to death. In terms of who's in charge of that room, evil is in charge of that room.
Objection, Your Honor.
That's who's in charge.
Sustained treason.
There's nobody in charge of that room. Sergeant Masha's not in charge. Sergeant Trombley's not in charge. They can point the fingers at each other all day. I don't care. Nobody's in charge of that room. And I want you to look. There's where Mr. Fisher's body camera is. And you don't need a ruler or a tape measure. You can see where his eyes are and how much lower that body camera is. And keep that in mind when you're assessing what it is exactly that he saw. Sergeant Trombley is apparently doing some things. He's doing paperwork. He's walking around the room. He's making efforts to tell this person to do that, other person to do that. Mr. Fisher's doing absolutely nothing but observing. And again, no reason for him to be there. This is the response to the supposed bite that is supposed to lead Mr. Fisher to believe that this is lawful use of force. and this is the result. And there he is, the defendant over in the corner, putting on his gloves. What's he doing? He's looking right at what they're doing to Mr. Brooks. Did he engage in conduct which created or contributed to a substantial and unjustifiable risk that Robert Brooks' death would occur? Of course he did. Did he have a duty to intervene? You listen to Judge Bauer's instructions about his duty to intervene, both legally and by his oath of office. It's in Department of Corrections rules and regulations. He signs for them every year that he undergoes training. Objective reasonableness standard. There are some instances where you don't need a definition of reasonableness. You know it yourself. This is one of them. If this is so reasonable, why are we repulsed at watching that video? The use of deadly physical force. We know their job is tough, but you shouldn't get the death penalty because it took you 2 or 3 requests to get out of the van. Good faith. Anybody see any good faith in those tapes that you just saw? What you're not supposed to do with an individual is handcuffed. He wasn't just handcuffed, he was leg shackled and hogtied. Was the risk of such nature and degree that disregard of it constitutes a gross deviation from the standard of conduct that a reasonable person would observe in the situation? A fancy way of saying, my God, what do you need to see before you act and try to save a man's life that you have a duty to save? Does any of this seem reasonable? Does any of this seem as if it was done in good faith? Robert can't even stand up. Mr. Fisher is joking with the nurses, joking with Sergeant Mashaw. Did he take that nanosecond to say enough? Did he say, I'm going to turn on my body-worn camera? Did he consciously disregard that risk? Of course he did. Of course he did. For 7 minutes, 7 gut-churning, nauseating, disgusting minutes, he stood in that room close enough to touch him, and he did nothing. There he is at 21:30:07, enjoying a good laugh. That's how concerned Mr. Fisher was. Then when he was no longer watching the show at 21:37, he stops to take a breath mint. Was Robert Brooks' death foreseeable? Foreseeable to anybody with a brain, 2 eyes, a conscience, never mind a 20-year corrections officer. Is it foreseeable that that man might choke to death? That he might gag on his own vomit and his own blood? You tell me how you can look at that as a layperson that you are and not realize that that man is in danger of dying. You don't need X-ray vision. There are limitations on the use of force, all of which were disregarded here. There are rules on deadly physical force, all of which were violated here. Watch Mr. Farina as he's administering the savage beating look back with a look of concern on his face. But then he sees that it's Mr. Fisher, and he relaxes and goes back to do what he was doing. Looks right at Mr. Fisher, and then goes back to doing what he was doing. And there's Mr. Fisher's reaction to all of this at 21:30:20. There's what he thought of all of this. The defense theory is not complicated. They don't have to present the theory. But their theory is, my guy never hit him. Yeah, it's bad what occurred, but certainly not a crime. Bad stuff was done by others, so he can't be guilty. My guy doesn't deserve a medal or a parade, but it doesn't make him a criminal, so you must acquit him. That argument is wrong on every level imaginable. He isn't charged with what Mr. Eisman says there's no evidence of. He isn't charged with beating Mr. Brooks to death. He is charged with recklessly causing Mr. Brooks' death, with being aware of what was happening, appreciating the risks, dismissing them, choosing them to ignore them. Although he was more aware of what was happening to Mr. Brooks than any of the 8 billion people on this planet, and although it was his job to act, it was the only earthly reason for Mr. Fisher to be present in the Marcy Correctional Facility was to act, to do something. He took an oath to support, protect, and defend the people that we put in his care and custody. He consciously disregarded that risk, even though the cloud of death was shrouding Mr. Brooks. And he acted by choosing not to act. Although he took an oath to do this, to do exactly that, to act. And by this disregard of his oath, this conscious disregard of the life-threatening risk that Mr. Brooks faced, was an inevitable link in the chain of Robert Brooks dying. And that makes him guilty. Not of murder. He's not charged with murder. He's never been charged with murder. But manslaughter, which he so demonstrably is guilty of. Listens to the judge's instructions about conscious disregard and risk of death. All of them fit his studied passivity like a glove, and indeed he played a role in Mr. Brooks' death. Because he's not as bad as the others doesn't mean he's not bad enough to be guilty. Because he chose to abandon his oath and put on rubber gloves and get no dirt under his fingernails doesn't mean that he doesn't share in the criminal liability for his washing his hands of a man who had 30 minutes to live after his entrance at the Marcy Correctional Facility. There's no argument about the facts here. Did he see it? Of course he saw it. He understand what he was seeing? Of course he did. You saw it too. What else could one believe? Did he consciously disregard the risk of what he saw? Isn't that just a nice way of saying willful ignorance? Going along to get along, just being one of the guys, this is routine, no big deal. Did Robert Brooks die as a result? How many opportunities in those 7 minutes did this man have to save Robert's life? One for every second, because that's how long they said it takes to say enough. Even flipping on his body-worn camera and announcing it to everybody would have saved Robert's life. You know that Robert is dead because of what others did, and what the defendant didn't do. It makes them all guilty. Guilty of different things, but guilty nonetheless. It's not an innocent bystander. It's not a bad employee. It's an act of criminal recklessness, conscious disregard of obvious and palpable risks by someone sworn to protect the inmates that we put in his care, including a 43-year-old, 148-pound man. I'm a student of World War II, and one of my favorite historians is Stephen Ambrose, and in his brilliant book, The Band of Brothers, which describes the journey of a group of soldiers as they fight their way from Normandy to crossing the Rhine. He described them in a single sentence that I've applied to you today. It is a time when ordinary men were called upon to do extraordinary things. I ask you 14 good people to do an extraordinary thing today, to bring justice to this man, to put a stop to this, to show courage, courage that he never showed, and do justice in this case, and return a verdict of guilty, manslaughter in the second degree. I wish you Godspeed, and I thank you.
Thank you, Mr. Fitzpatrick. Ladies and gentlemen, my next order of business is to instruct you on the law. That's going to take some time. You've already been sitting patiently by speaking this morning, and I would prefer not to interrupt your work here with our lunch break. So I'm going to give you your lunch break now. I'm going to remind you of your admonitions over the lunch break. In particular, I'm going to emphasize the part for you about not discussing the case with anyone. You might be tempted to do so because you've now heard the closing arguments. You have some ideas in your own minds. Resist that temptation. You have no context in which to place those arguments right now because you have read the law. You must not discuss the case over the break. Do not read, watch, or listen to any accounts of the case in the media. Do not conduct any research on your own. Do not give a location where the crimes alleged to have occurred. Continue to keep an open mind. If anyone tries to influence you in any way, you must report that to me immediately. Please be back by 1:15, quarter after 1, before we start at that time with the court's instructions. Enjoy your lunch.